Good evening. My name is John Milburn, and this is Laws 12059 Conveyancing. We're into week 2. This is for Central Queensland University. We have a number of people online. Thank you very much for joining us. We have a small but very keen cohort undertaking the study of conveyancing this year. This week we're dealing primarily with the real estate agent. But before we do, just a few topics that I wasn't able to cover last week due to constraints in time. The first actually impinges on obligations for real estate agent because just a few words about the duties imposed on sellers. Buyers have rights in certain circumstances that go beyond contract, and the law provides buyers with equitable rights in relation to certain things that might occur during a conveyancing transaction or perhaps the negotiations leading up to the signing of a contract. In other words, coupled with the equitable rights of a buyer are fiduciary duties and trust duties that might be imposed on a seller. Have a look in that regard at Tanwa Enterprises. It's a decision of 2003, 217 CLR at 315, and that's a High Court decision, of course. A difficult area that I'm not going to answer now, but I just want you to think about is in relation to the duty of a seller to disclose defects in relation to a property about which the seller is aware. And then going beyond that, segueing into this week's work about real estate agents, what if the agent is also aware of those defects, or what if the seller, or more likely the agent, turns a blind eye and has reckless indifference in relation to those things. Going beyond that, there is the question of to what extent are sellers liable for any statements they may have made or statements that they may be deemed to make because their agent made the statements? Or is it possible in certain circumstances for an agent to be liable for a statement and not the seller, which goes to the issue of the extent to which the seller has authorised the agent to make representations. So again, no answers there, but a few things that I want you to think about, particularly when you're undertaking your reading. And think about the potential remedies available to, well, in this case, buyers, as a result of things that might occur and the property not being what the buyer had thought it to be. So we know that conveyancing law is based on contract law. I think we mentioned briefly that there are some refinements, if I can use that term, as they relate to conveyancing. So contract law is the basis. Land law is another basis, of course, for conveyancing. But when it comes to contract law, remember some of the refinements. So, for example, Section 59 of the Property Law Act, which is effectively the old statute of fraud requirements, that there must be a document in writing signed by a party and the document must be sufficient in detail to constitute a contract. That doesn't have to be a lot of detail, even though we have typically in Queensland, for example, standard form contracts. A contract can comply with the obligations under Section 59 and the statute of fraud requirements with minimal input. So the key elements are whether we have something that records in writing, signed by the party or signed by a party for that party, something that records the property, the price, and so the location. So the property and the price are the important things, and the parties, of course. So the 3 Ps there. So if you have those things, the example that I give is people that are negotiating a real estate deal over lunch. They write the parties, the property, the price on a napkin. They sign it. Is that sufficient? Well, the answer is probably yes. That's probably sufficient to constitute a contract in terms of contract law as refined by statute. Conveyancing practice. Just a few words. The obligations generally for a buyer or buyer's solicitor: the bare bones, investigate the title, prepare the transfer documents, attend to stamping, which we now call paying the transfer duty, settling the transaction and registering a title. That is, if the title is to be registered, otherwise a financier would do that. For a seller, investigating the title, that's a step sometimes overlooked. It's still an obligation on a seller solicitor to do that. Receive and sign the transfer documents, release any mortgage or encumbrance that's capable of being released on the title and settling. And in relation to both, solicitors have the obligation generally to advise buyers or sellers, as the case may be, pre-contract. Just be aware of that important other step, pre-contract matters, and we'll see a lot of that during the course of this unit, how that comes into effect. Just a word about one of those steps, investigating of title, that usually occurs in the context of undertaking a title search. Usually, good practice is undertake a search at the start of the process and as close as possible as you can to the time of settling the transaction. And whilst that is primarily important for buyers' solicitors, arguably it's important for seller solicitors also, particularly the first search. I'm of an age now, and having been involved in study or practice of law since the 70s, where I can give you some insight as to what conveyancing was like in the old days, to use that term. So in the early 80s when I started, I mentioned some of the problems that occurred to me as a result of my first settlement and as a result of my first conveyance. Well, in addition to that, general practice back then was to undertake a title search, but the title search was not electronic. We didn't have computers when I first started. What it meant was literally walking to the titles office, the registrar of titles office, asking for the volume and the folio so that you could inspect the folio. You think, what's a volume and what's a folio? So all the titles were recorded in duplicate. The original title was given to the owner of the property. Now a title reference. Thank you, Bronwyn. The original was given to the owner of the property as evidence of ownership, noting the person's name, but there was a duplicate. There was a duplicate original, and that duplicate original was maintained. It was kept by the registrar of titles, and for convenience, they were put into books. We call those books volumes, and each volume contained 150 duplicate original titles, and each one of those pages, each one of those titles was given a folio number. So it had a volume and then a folio. So for us to do a search, we would go to the titles office and we would say, I need to look at volume 5516, obtain the book, literally obtain the book, put it on the counter and flick to folio 117, which was the title, and then handwrite. There was no such thing as photocopying. You'd handwrite the notations and race back to the office. So we've come a long way, but Bronwyn's right. What you now see is title references, but there is a little bit of a throwback to the old volume and folio. I think, is it at the start they have a number? It was either 1 or 3 or 5. One is one for Southeast Queensland, and other numbers were given for Central Queensland and Northern Queensland. So I think there may have been something like that. So there's the 1, and then you've got the reference to the volume, and then the folio. I'm not sure if there's a number after that, but you can use that to trace it back to the old days when we used to use books. Anyway, during the course of the unit, please excuse me if I refer to some of the things as they used to be. Part of the reason for doing that is so that you'll be very grateful that things are so much easier now in some ways. Much more difficult in other ways, but some ways it's a bit easier. We used to do the same thing for the process of stamping. We would have to, for an urgent stamping, we would actually have to go up to the stamp duty's office and wait for an assessor and make an appointment and actually have it stamped on the spot. Anyway, it's all very different now. So The solicitor has a role to play, of course, in terms of representing clients in general sense, and solicitors need to take very great care about the extent to which they purport to bind their client. They need to be very careful in written and verbal communications, and it's very easy to make a mistake. Let's take this example. You're acting for a seller. Settlement's tomorrow. The buyer's solicitor's conveyancer contacts you and says, we've got some problems, I may need an extra day or two. Is that going to be a problem? It's too easy in the course of conveyancing with people that you're working with all the time to make a statement, something like, look, I don't think that'll be a problem. I've got a really good client. I'll get back to you. You contact your client. The client says, under no circumstances do I want you to grant that extension. Where does that leave you, having made that comment, that communication, something to the effect, I don't think that'll be a problem. I'll get back to you. Now, it may be there's enough wriggle room in that scenario, but you've got to be very careful because you might just go over the line. You might give the impression and the other side might take that as being a yes. So be very careful in terms of your communications. Always work on the assumption that everything that you say or write is going to be the subject of a Supreme Court action. And ask yourself, will I be comfortable in making this statement as to what I did or what I said if I'm giving evidence before a Supreme Court judge in a trial regarding something that has gone wrong in the conveyancing process? That's pretty much a test. So be on guard, be professional, be polite, but don't be afraid to be formal when that's required. Just be very careful about the conversational aspects. Does anyone wish to say anything about this? Has anyone got any versions or issues that have arisen in the past to do with things that may have gone wrong in that sense? Yes, Bronwyn?
I just had a thing today where I just had to be careful on a building and pest, and our buyer had wanted to ask for a pool safety certificate to be provided by the seller because the agent had indicated that. So the other side came back and agreed to our amendments due to a building and pest issue, but they didn't specifically say that they would agree to the pool safety certificate. So I had to make sure I went back to them to get confirmation of that specific point because it wasn't clear in what they'd returned to me. So you just have to really make sure you double check everything and don't just, they go, oh, we agree to this, but they haven't agreed to every specific point.
And at the same time, you're working within time constraints. There's a lot of pressure in conveyancing, and you've got to work on the basis that if the client says something different to what you say, then you've got to have a diary note to back it up. Otherwise, the court will believe what the client says. So you're thinking about four things at once. You're dealing with pressure. You're trying to maintain contact with client and with the other side. And at the same time, you've got to be able to record notes. Just on that point, I use voice recognition extensively, even in court. And I find that it's, I recommend this as something that you might consider in the course of obtaining instructions or taking statements as well. So, for example, as I speak now, if I pushed a button and I use drag and dictate, I could be recording very accurately in writing what I'm saying to you now. I'm not doing that, but I could. And I actually have a YouTube video where I demonstrate that quite clearly. So keep that in mind as something that might be useful, particularly if you wish to maintain eye contact and you want to record something accurately. All right, so I mentioned that when you're acting as in a solicitor's office and you're representing a client pre-contract, you need to be especially on guard. You need to be on guard to deal with specific questions that are asked of you. You need to be on guard for things that were not asked of you but might be expected of you if things went wrong down the track. Let me give you this example. A client comes to you, you're in a solicitor's office and you're acting for the buyer. They bring to you a contract yet unsigned and ask you to review it with a view to signing it. In the contract, it provides for a special condition. The contract relates to the purchase of the acquisition of an off-the-plan unit. Do you know what I mean by off-the-plan? So it's to be built, but it's at a stage where it can be lawfully sold. So it's off the plan, and there's a special condition which says something to the effect that for the first 12 months, the developer will guarantee a return of 7% per annum. And what duties does a solicitor or a conveyancer have in those circumstances? Is it to check the wording and say, yes, that looks accurately worded, I understand that? Or do you have to go beyond that? Even though the client may not ask for specific advice, do you have to go beyond that, ask a few more questions, or provide a little bit of gratuitous advice? Any thoughts? And in fact, what could go wrong there? Looks a pretty good deal. Yes, Bronwyn?
The 7% is not guaranteed, even though they call it a guarantee.
Even though they say the developer guarantees it, there's a difference between having that commitment in writing and actually having the cash. All right, so what are the things that might go wrong in terms of that disconnect?
The actual amount of money that rental that comes in may not be the actual 7%. It may be, you know, that less cost. You'd have to look at the clause to see whether, you know, it says it's an estimate or, you know, something
along those lines. Or a very simple one might be this. Typically, a developer would be a company. It might be a $2 company, so to speak, and it may be that once the development is sold, the company's wound up and gone. It's vanished. So who are you going to sue for your 7%? So you might say, well, here are some of the risks associated with the transaction. It's ultimately a matter for you. Rachel says they might become insolvent. Exactly. So there are those risks. Have a look at a case of Littler against Price, 2005, 1 QDR, 275 in that regard. So the message so far this evening is twofold. Conveyancing is not easy. You'll hear me say that a lot. And secondly, be on guard all the time and assume that everything that you say or do or record is something that you would be happy to say in a witness box situation in the Supreme Court. That's the rule of thumb. Okay, Sarah. Is Sarah here? Yes, Sarah. Thank you very much for your information on UCRU, giving us the heads up about the Land Title Practice Manual having been updated on the 9th of July. And I think you did provide a copy of the link to the new practice manual. Do you want to tell us anything about that, Sarah?
With regards to the updates?
Yep, and you know, it's just the practice manual generally.
Yeah, so we use the Land Titles Practice Manual quite often. Things like, how can I explain? A Form 1 transfer that you'd use that you have to provide at settlement, that, as you said, a buyer's solicitor produces in readiness for settlement for the seller to sign prior. It basically sets out the requirements that needs to go into that document. So if there's anything that you're unsure of, you can always go to the Land Titles Practice Manual. And not necessarily just for transfers, but it can be anything, like a general request. So if you want to change something as simple as a spelling of someone's name, you can do it that way, and it shows you how to do it. If somebody passes away and they're joint tenants or transmission application, things like that, you can do it all through there, and it basically sets out step by step exactly what you need to do and how easy it is to do it.
Excellent.
Yeah.
So thank you, Sarah. So if you haven't yet taken up on what Sarah provided in the link, please do so, because the Land Title Practice Manual will give you a good idea of what conveyancing is like in practice. Those of you that are in conveyancing, you'll know all about it. But if not, have a look at it, because it gives you a very clear idea of the forms. And from the forms, you get an idea of what it is that the Titles Office, the registrar, wants and what you need to ask in terms of information. So a very good, valuable resource. Thank you. Okay. What I thought we might do in this unit is something a little different. The text is excellent. I really like this textbook. It's comprehensive, it's got great information, but I thought rather than essentially reproduce information in a summarised form from the text, we might talk around the topic, and what I'd like to do is use a lot of case examples. So here's case one. I'm going to ask you to listen carefully, write some notes, because I would value your thoughts and discussion about this. I'll give you my thoughts, but what I say won't necessarily be right. I don't mean that in the sense that I'll make a mistake, but there are different ways to look at law. I'll just expand on that. You know, I love conveyancers. I respect conveyancers. I think they're great. They work really hard and they work under pressure. But just sometimes, in my experience, conveyancers have been a little bit black and white in terms of what they believe to be a solution to a problem. So when I'm teaching equity, for example, or some other subject, I might use conveyancing situations as an example and say, yes, but don't think of this purely in contract terms. You've got to think of it in terms of trust law, equity, things like that as well. Okay, so when I say I may not be right, there might be other perspectives to consider. Here's the case number one, and I've called it the agent who lost a deal by delay. This was what actually happened to me. On one occasion, I was involved in a transaction acting for a buyer. The buyer attended my office. This is back when I was a solicitor. I'm a barrister now, but when I was a solicitor, advised me he'd signed a contract the evening before. He wanted to terminate the contract but was unsure about the process, and I immediately sent a letter revoking the offer on his behalf to the real estate agent for the seller and to the seller named on the contract. The agent contacted me within minutes, but the client was still there and said, sorry, too late. The vendors, which are the sellers, signed the contract the night before, so sorry, too late to revoke the offer. What are your thoughts? What are the things that come to mind?
They could terminate under the cooling off period, but risk a penalty of 0.25% of the purchase price.
Exactly. Can every buyer? So when I pose the problem, I don't think I said what type of property, or so is it every buyer? Is it every property? Or are there constraints on the option to exercise the cooling off period?
I know with mortgagee possession sales that we have, they've removed that right. So they're unable to pull out for the cooling off period.
Any other restrictions where you can't?
Auction contracts.
Auctions, and not just at the auction, but within a period of time after the auction as well, isn't it? All right, so mortgagee sales is another good one. So just generally speaking, yes, but that's for residential sales as well. What about for what if it was a commercial property that we were talking about? Can you have the cooling off period for a commercial property?
John, we can't hear you.
Sorry, thank you. So Sarah says, one thing you could consider doing is exercise your right as a buyer under the cooling off provisions. You may suffer a penalty, but at least you'll be able to be out of the deal. I've said, yes, but what about these exceptions? What about these scenarios? So be prepared to think more laterally. But that's one scenario. Now, is that the only advice that we can give to the client, or are there other things that we could say to the client? Yes, Bronwyn.
What if the contract hasn't been issued, even if it's been signed by the seller, and it hasn't been issued by the agent?
What do you mean issued?
Like sent to you as the purchaser's solicitor,
Yes.
by the agent or the seller. I don't think it would be.
Okay. So if it hadn't been, just to adopt your wording for the moment, issued, if it hadn't been issued, what entitlement would the buyer have in those circumstances? What could you advise the buyer?
I think it would depend on the timing of when you sent your correspondence through, and whether the contract had been sent through by the agent. If you had sent your correspondence first, I think you would be able to say to the buyer that they're not obligated to continue with the contract.
Okay, so that's an option. Let me pose this to you. A contract for real estate is a contract. That means we need to consider contract law. What are the elements of a binding contract? There's 5 that I've got in mind. I'll give you a hint. Offer, acceptance, I can lip read.
Yeah, acceptance. Consideration.
Consideration is number 4. What's number 3?
What is it? Offer, acceptance.
Number 5 is intention to enter into legal relations. Offer, acceptance. Number 3 starts with C. I'll give you Marjorie. What do you say?
Have to communicate that.
Communication. Thank you very much. Offer, acceptance, communication. So what we would say is contract may have been signed by the seller, but not formed at law because the offer was revoked prior to communication of acceptance. Therefore, there is no deal. So there are a few ways that you could look at that. And of course, the issue of when the cooling off starts, etc. Okay, so when you're thinking about the cases, think about how these might be applied in practice. Case number 2, the case of double commission. An elderly woman consulted me, fearing that she'd committed herself to paying double commission. She signed an exclusive agency with one agent and then sold the property through a different agent. She comes to your desk, she came to the desk stressed, both agents demanding full commission. Thoughts? Those of you that have studied ADR with me.
Has she exceeded the time frame?
A time frame?
Has she exceeded the time frame?
Okay, so was that you, Sarah, was it? Okay, so I've just missed that one, sorry.
Sorry, has she, what's the time frame that the exclusive agency was in place? Has she gone past that, which would mean that it's no longer place?
Yep, so good point. Make sure that we look at the documentation. But let's assume for a moment it was sold, the property was sold within the exclusive agency period. I think she's got problems, hasn't she? Can anyone tell me what is an exclusive agency and contrast that with other forms of appointment of a real estate agent? Okay, so an exclusive agency entitles, in general terms, an agent to claim commission in circumstances where the property is sold, full stop. The agent need not be the causal effect of the sale in an exclusive agency to claim commission. Contrast that with a sole agency where the agent would be entitled to claim a commission in all circumstances other than when the seller is the causal effect of the sale, as opposed to the third type of agency, which is an open listing, where the agent would need to establish that he or she or it was the causal effect of the sale in order to claim a commission. But the concern that I'd have there is that if the client had signed an exclusive agency and then another agency was the causal effect, the client may well be facing double commission. Any thoughts? All good? Okay. Now, the client is only agreeing to one of them selling the property, but having signed the exclusive agency, they've really got some problems there. Case number 3, committed to 2 purchases. This is the contrasting situation. So here's where a buyer consulted me and said, look, I've signed 2 contracts to purchase 2 different properties. And I did that because I want to try and play one off against the other. The intention is I don't mind which one I buy, I just want to get the best deal. So I'm doing the reverse situation here. I'm offering myself to a number of sellers and I'll take the best deal that's offered. It's normally it's in the reverse, isn't it? So thoughts, any dangers?
You could be stuck with 2 contracts.
Yes, could do. And that can happen. So what they need to do is be very careful to revoke any offers that may have been made and left out there. And it happens in practice because, people might make an offer on a house. The real estate agent says, let's commit it to writing. They commit to writing. They don't hear anything for a little while. They then find another house the next day. They put that in writing. They eventually get the contract and they forget about the first one sitting out there. So tidying up loose ends is important. I don't know, as a solicitor, how you do that. If they don't tell you that they've signed another contract, it's pretty tough to give them general advice in that regard. Okay, so key legislation as far as agents are concerned: Property Occupations Act 2014, Queensland; Agents Financial Administration Act of the same year. And bear in mind that agents can become subject to the regulatory framework under the Australian consumer law and consumer protection legislation. Later in the studies, we'll talk about specific issues to do with the completion of contracts and the conveyancing process. But I'm going to touch on some of those now because they have particular relevance to the role of real estate agents during the contract stages in preparing the contract. Agents, firstly, need to be careful about the extent to which they go in drafting contracts because they're not legal advisors and they don't want to be pinged for giving legal advice. So agents need to be careful about that issue, and they need to be careful about how they prepare a contract. But if they do, they need to take certain care in some areas. So the first is they don't want to put a seller in a difficult position by actually getting the name of the seller wrong. I mentioned the importance of doing a title search. That applies for lawyers, but it also applies for real estate agents because they should not just take the word of their client that the property is, say, in 2 names, because it might just be in 1 name or vice versa. And what happens if the agents prepare a contract, it's signed by the buyer, we find in fact that the property was registered in 2 names, but they only had 1 person sign the contract or vice versa? What are the complications? Or is there an easy fix, or are there issues here?
The buyer could terminate. because
Yes.
it's not really a valid contract.
The buyer could terminate. There might be that issue. Another issue is that if the buyer says, no, I'm proceeding, and forces the seller to rectify the title, if the seller can't convince the Office of State Revenue that it was a genuine mistake, the Office of State Revenue might say, well, we'll have two lots of transfer duty here, because we'll assume that there was another transfer not recorded in writing to get the property from two names into one or one name into two, that sort of thing. So there are some issues, and the general rule is make sure that you get the seller's name right. Do a title search, have a look at the rates notices, look at general documentation to support what's being said. Now, there are some complications. One is that, a party may have passed away. Sarah mentioned before that if you look in the Land Title Practice Manual, you have a good way of working out how to do a transmission by death, or in the case of a joint tenant who dies, a record of death. So if someone passes away, then you want to ensure that the property is transferred across to the personal representative of the estate in a transmission by death, or if it's a joint tenancy situation, you record the death of one, which means that it vests entirely in the name of the surviving owner. You can still undertake a conveyance and have a contract signed, but in those circumstances, you need a special condition to say, look, it's subject to this occurring down the track. Another real problem for an agent is an undisclosed trust, because sometimes people will buy a property as trustee for a family trust or a unit trust or something else, or a superannuation fund. And as an agent, you need to ask the question, who is in fact the seller, and is there a trust? And if there is a trust, has it been disclosed on title? Is it undisclosed? That might have some complications down the track, which will come back on the agent potentially in terms of issues to do with tax or stamp duty. I say stamp duty is a shorthand, it's really transfer duty these days. What about the buyer? If the agent's dealing with the buyer, are there any potential complications there? What would a buyer need to consider? Sorry, what would an agent need to consider in the context of a buyer? Anything? What if
not giving false information, like
yes.
or like what could be construed as by the buyer as information they believe, and then it's not completely true?
Yes, so there is that aspect. But I guess my question was more in terms of the status of the buyer. I'll be more specific. What if the buyer is not an Australian citizen? Should that create any concerns to the agent? And if so, what?
They have to pay additional stamp duty.
Oh yeah, you're right. Sorry, I was just going to talk about FIRB approval, if that's what you're referring to.
Yes, and the acronym FIRB, Sarah, is?
Foreign Investors Review Board, from memory?
Close.
Yeah.
Foreign Investment Review Board, which is part of the tax office. So have a look at the tax office website for the Foreign Investment Review Board, and all of that is under the Foreign Acquisitions and Takeovers Act of 1975. And you'll see within there Section 4 and Section 5 relate to the definition of foreign person. Now, the reason that's relevant is that your deal may fall over if you cannot obtain Foreign Investment Review Board approval, which will mean that as an agent, you're going to have a very upset client. There are some people that are exempt from FIRB approval: Australian citizen, New Zealand citizens, people that have an Australian permanent visa, people that are purchasing jointly with an Australian citizen or New Zealand citizen or Australian permanent resident. Sometimes also the nature of the property being acquired will influence the extent to which the Foreign Investment Review Board will grant or not grant its consent to the acquisition. So, and Rachel has said identification. is a really important point, and just generally you need to be aware of that. Okay, time is getting away, but I have another case. This case relates to the case of encumbrances. Can anyone tell me before we start what is an encumbrance? Because those of you who haven't studied much in conveyancing, what's an encumbrance? You should have done this in foundations. A mortgage is an example of an encumbrance, yes. A caveat, yes. An easement, yes. One more. I mean, there's quite a few more, but just one more common one. Profit a prondra, less common, but yes. A lease is another one. Okay, so a caveat, an encumbrance is essentially an interest that might generally will burden the property. It means that someone else has an interest in the property. Okay, here's the case. Ready on the notes? I want to ask you some questions about this. An elderly gentleman comes to you with 2 contracts he signed on the weekend. His wife passed away, so the family home for 30 years was way too big, too much maintenance, so he sold the family home, which had been his home and his wife's home for 30 years. So that was one contract. The other contract was to buy a small unit. Both contracts signed, apparently sealed, ready to go. Now, the agent, so the client spoke with the real estate agent who was involved in both deals, and this is what happened. In relation to the sale of the family home, the client said to the agent, look, there is an encumbrance. It's an easement. My neighbour is able to drive his truck down the boundary, the side boundary. And the agent said, no, in the encumbrances section of the contract, we write nil because it's only a right of way. It's not an encumbrance. Sarah's saying that's wrong information. Bronwyn agrees. The second contract is a little different because in the second contract, the person who owns the unit, the seller, has a mortgage, and the agent says, I know a mortgage is an encumbrance. There's a section in the contract that says encumbrance, so I'll write down mortgage. So for the sale contract of the family home, it says encumbrances nil, and for the purchase of the house, the purchase of the unit, it says encumbrances mortgage. It's all signed. Are there any legal implications for your client in relation to both contracts? And if so, what are they and what remedies can we consider doing? You'll notice that every question I ask, I'll always ask you, what are the remedies? What can we do about this? Okay, so are there any legal implications? Any thoughts?
By not disclosing the easement on the sale contract, that is a right of termination for the buyer. Whilst they say, oh, you know, it's just for them to come in and out, it's an access easement and it would be listed on the title. So it's a necessity because it will affect the ongoing purchaser. With regards to the purchase, the mortgage doesn't need to be listed as an encumbrance because that will come off when you go to settle. So it won't affect the purchaser after that time.
Okay, so thank you for some thoughts there. I'll ask for some refinement on that and I'll provide some further comment. Any other comments, any thoughts?
Should they have, like, we don't know whether they've made the purchase contract subject to the sale of the sale contract. Like, they should make sure there's a special condition that,
yep,
you know, because they would need to sell that house to be able to buy the unit.
Well, yeah, although in this case, you know, maybe the client's got enough cash to buy the little unit anyway. But yet, generally speaking, that's a good thought. It wasn't the thought I had in mind, but it is a good thought. And I like the lateral thinking. Keep up the lateral thinking. It's good. Any other thoughts? No? All right. Well, here are some of my thoughts. Firstly, in relation to the sale, I totally agree with Sarah. The easement is an encumbrance And on the contract, where it says encumbrances, the easement should be included. And Sarah, I also agree with, is right, that it is only those encumbrances that will remain after settlement that should be included on the contract. Which means, of course, when we get to the buyer, to the unit, I'll be saying something about the agent including the mortgage. But just on the issue of the encumbrance being the easement, I'm not sure that the buyer would automatically have the right to terminate the contract. The buyer might have the right to terminate the contract, but the law, I think, would be that the buyer would need to establish material prejudice in any application seeking confirmation from a court as to the right to terminate the contract. A case I used to refer to a lot when I was doing conveyancing and a long while ago, but Liverpool Holdings against Gordon Linton Car Sales Proprietary Limited. So that's Liverpool Holdings. It's 1979 QDR 103. A slightly more recent case is Stott against Dunn, which is 2002 QDC 365. The court will consider the size of the encumbrance. I mean, for example, if it's a right-of-way which is very modest, just enough for a car on a property that is 100 acres, the court might say, well, you can't get out of the deal for that. So the size of the encumbrance, particularly relevant to the property, may be a factor. The court might also consider whether the existence of the encumbrance has the effect of diminishing value in the property. If you're talking about a small lot in the city and there's an encumbrance and it means that you can't knock down the old house and build the units, then that may have a substantial bearing on your decision as a buyer and the impact on the buyer's use generally. So there are a few things that you might want to consider. Now, in terms of the purchase, and Rachel, I might just get you to mute your microphone unless you want to ask a question. I think we can hear you typing. Thank you, Rachel. I like when people unmute the microphone if you want to ask a question or make a comment. Now, regarding the purchase, I think your client has a bit of a problem here. You may have to go to a court to seek to rectify the issue on the basis that it's a mistake, but technically, your client must settle and take over the mortgage because in the terms of the contract, it provides that the encumbrances section, have a read of it. I might be wrong, but have a read of it because I think it provides that any encumbrance which is listed on the contract in the encumbrances section is something that will remain on title after settlement. That being the case, technically, the buyer would have to pay the full amount and also take over the mortgage. Yes, a win for the seller, but not intended. All right, so just watch out for that. And always, it's a matter of going back to the contract to have a look at the terms of the contract. Any further comments about that?
I do have one, John. It's Rachel.
Yes, Rachel.
Just that if the original easement wasn't listed as an encumbrance and was an equitable right, then when the transfer took place, if it was bona fide purchaser for value without notice, then basically the right of way would disappear, wouldn't it?
What about the interests? Well, no, I'm not sure about that. What about the interests of the party that had the benefit of the easement? You know, the neighbour who for the last 40 years has been driving his truck down that easement. I mean, it should be registered on the title. I think Sarah made that comment, or maybe Bronwyn, but it should be on the title. Sometimes they're not, which I guess is getting to the area where you're discussing, Rachel. But I think it would be, I don't think you could argue bona fide purchaser without notice. But it's good thought, but I don't think so.
We've had a case like this just recently, actually. A conveyance, a property that was in the middle of nowhere, completely landlocked by government or council land. And someone, no idea who, had installed a driveway through council land onto our client's land. No access easement on there, no actual agreement. There was an understanding between the council and the developer, and our client was selling. I said, well, you've got to disclose this. You can't, there's nothing here to say that they might turn around and say, no, I'm not going to let you access the property anymore. I said, and then you're going to be in real trouble with the buyer if you don't, because you knew about it and you haven't said anything. So there's some issues here. But, you know, it still happens even now. And the house was only, I think, 7 years old. So it doesn't matter how old the property is, it could still happen.
Absolutely. All right. Well, thank you for those thoughts. Time is getting away, so I won't keep us much longer, but I just want to raise a few other things. When the agent's preparing a contract and comes to the finance section, my recommendation, at least from a buyer's perspective, is not to include a clause that simply says amount of finance sufficient to complete. Now, I don't recommend that for a buyer. Why do you think that would be the case? I mean, for a seller's perspective, it's probably not so bad. But why would you want something other than that if you're a buyer in a finance clause? Any thoughts? Yes, Sarah says the financier may only provide finance in that amount, maybe stamp duty and legal fees. So there's some issues there. Interest rates, yep. What about certainty? I mean, what does it actually mean? What if, for example, the buyer was able to get enough money from a bank which was just enough to buy the property, but not enough to then pay, you know, the transfer duty or stamp duty on the legal fees, which is Sarah's point, I think. So it's enough, it's sufficient, but it's not really sufficient. Or it's not enough to give them any form of buffer, or it's not enough to undertake an improvement or necessary improvement to the property. Whereas if the buyer specifies a certain amount, saying, look, unless I get $400,000 finance, I don't want to proceed. Maybe I could squeeze into it with 360,000, but that's just too tight. I really need 400 to be comfortable about it. From that perspective, from a buyer's perspective, put in the amount in the contract that you say is certain and also comfortable. We're going to deal with case number 5 next week, but in the meantime, I just want to mention tree orders. Does anybody know anything about tree orders? What are tree orders, and what is that? Does that have a bearing? Yep.
You have to disclose them in the contract. If there's if you've got a dispute with your neighbour, or there's neighbourhood fences and trees, dividing trees or fences or something like that. I can't remember exactly what it is. Neighbourhood,
yes. Okay. It used to be the old Dividing Fences Act. It's now the Neighbourhood Disputes, I think, Resolution Act or something. But tree orders, you need to undertake a search through QCAT, the Queensland Civil and Administrative Tribunal, and those tree orders that are made through the tribunal actually remain, they burden the property. So have a look at that. Just one that I did last year is a case of Oliaro against Ross. So see if you can find that, and you'll get an idea of the sort of orders that could burden a property. So if you're acting for a buyer or a seller, you need to ask questions about that also. Okay, that'll do us for tonight. Case number 5 and the couple wishing to purchase their first home will be what we lead off with next week. So any questions, comments? All good? Okay. Thank you for your patience. We'll see you next week. Please keep up your reading. Read in advance. Read the contract. Okay.
Sorry, John, just one thing. I put a message on YouCrew as to size font you're happy with on the assignment. So to try and keep in with the theme of doing the article, it's just a bit difficult to do that if you're doing 12-point font.
Oh, okay, sure.
Like it won't stay on one page.
Yep.
So do you have any problems with it being a smaller font, or do you
Not at
prefer
all.
us to just do an essay style and leave with the article?
No. Generally speaking, if it's an assessment piece, I would recommend 11 or 12 point font. But if it's for something like the article and there's some special reason to change the font size, I'm flexible with that. So there's no problem.
Okay. Thank you.
All good. Okay. Excellent. All right. We'll see you next week. Bye.